Praetor was a title granted by the government of ancient Rome to men acting in one of two official capacities: the commander of an army, or an elected magistratus, assigned various duties. The functions of the magistracy, the Praetora, are described by the adjective, the Pretoria Potestas, the Praetorium Imperium, and the Praetorium Ius, the legal precedents established by the praetors. Praetorium, as a substantive, denoted the location from which the praetor exercised his authority, either the headquarters of his castra, the courthouse of his judiciary, or the city hall of his provincial governorship. History of the title. The classical era authors do not describe the events leading to the praetorian title origination, but the writings of the late Republican statesman and attorney Cicero explored the philosophy and uses of the term praetor. The prefix prae is a good indication that the title holder was prior, in some way, in society. Livy mentions that the Latini were led and governed in warfare by two of them and the Samnites by one. A dictator was called the Praetor Maximus. The use of the adjectives in a large number of circumstances testify to a general sense. The leadership functions of any corporate body at Rome might be termed praetorial. The Praetoria Potestas in Republican Rome was at first held by the consuls. These two officials, elected on a yearly basis, inherited the power of the king. Very likely, the king himself was the first praetor. The best explanation available is that of Cicero in De Legibus, in which he proposes ideal laws based on Roman constitutional theory. Regia imperia duo suntor, ique praeenda illudicando consulenda praetors illudices consules appellamino, militia e summum ius habenta. Let them have the supreme right of command of the military. This etymology of praetor became and remains the standard. Cicero considers the word to contain the same elemental parts as the verb praere. In exactly what way he goes before did not survive. Livy explains that in the year 366 BC the praetura was created to relieve the consuls of their judicial duties. The praetor was, in an English sense, the chief justice, and yet more than that. The consuls were his peers. He was elected by the same electorate and sworn in on the same day with the same oath. Until 337 BC the praetor was chosen only from the patricians. From then on, praetors appear frequently in Roman history, first as generals and judges, then as provincial governors. Beginning in the late Republic, a former praetor could serve as a propraetor and act as the governor of one of Rome's provinces. Praetora. The praetorship was created around 367–366 BC to take over part of the duties of the consuls. The first man to be elected to the new praetura was the patrician Spurius Furius, the son of Marcus Furius Camillus. In exchange for the election of Lucius Sextius, plebeian leader, as one of the consuls for the year, partisan politics greatly influenced the outcome of elections. The elected praetor was a magistratus curalis, exercised imperium, and consequently was one of the magistratus majores. He had the right to sit in the cella curalis and wear the toga praetexta. He was attended by 6 lictors. A praetor was a magistrate with imperium within his own sphere, subject only to the veto of the consuls. The potestas and imperium of the consuls and the praetors under the Republic should not be exaggerated. They did not use independent judgment in resolving matters of state. Unlike today's executive branches, they were assigned high-level tasks directly by senatorial decree under the authority of the SPQR. Livy describes the assignments given to either consuls or praetors in some detail. As magistrates, they had standing duties to perform, especially of a religious nature. However, a consul or praetor could be taken away from his current duties at any time to head a task force, and there were many, especially military. Livy mentions that, among other tasks, these executive officers were told to lead troops against perceived threats, investigate possible subversion, raise troops, conduct special sacrifices, distribute windfall money, appoint commissioners and even exterminate locusts. Praetors could delegate at will. The one principle that limited what could be assigned to them was that their duties must not concern them with minima, little things. They were by definition doers of maxima. This principle of Roman law became a principle of later European law. Non curate minima praetor, that is, the details do not need to be legislated, they can be left up to the courts. Praetors and their duties. Republican in 246 BC, the Senate created a second Pretoria. There were two reasons for this: to relieve the weight of judicial business and to give the Republic a magistrate with imperium who could field an army in an emergency when both consuls were fighting a far-off war. Praetor Peregrinus. By the end of the First Punic War, a fourth magistrate entitled to hold imperium appears. The praetor key into peregrinos ius dicit. Although in the later empire the office was titled praetor inter civis a peregrinos, by the time of the 3rd century BC, Rome's territorial annexations and foreign populations were unlikely to require a new office dedicated solely to this task. T. Corey Brennan, in his 2-volume study of the praetorship, argues that during the military crisis of the 240s the second praetorship was created to make another holder of imperium available for command and provincial administration inter peregrinos. During the Hannibalic War, the praetor peregrinus was frequently absent from Rome on special missions. The urban praetor more often remained in the city to administer the judicial system. Praetor urbanus. The praetor urbanus presided in civil cases between citizens. The Senate required that some senior officer remain in Rome at all times. This duty now fell to the praetor urbanus. In the absence of the consuls, he was the senior magistrate of the city, with the power to summon the Senate and to organize the defense of the city in the event of an attack. He was allowed to leave the city for no more than 10 days at a time. He was therefore given appropriate duties in Rome. He superintended the Ludi Apollinaires and was also the chief magistrate for the administration of justice and promulgated the praetor's edict. These edicts were statements of Praetor's policy as to judicial decisions to be made during his term of office. The Praetor had substantial discretion regarding his edict, but could not legislate. In a sense, the continuing edicts came to form a corpus of precedents. The development and improvement of Roman law owes much to the wise use of this praetorial discretion. Additional praetors. The expansion of Roman authority over other lands required the addition of praetors. 2 were created in 227 BC, for the administration of Sicily and Sardinia, and 2 more when the 2 Spanish provinces were formed in 197 BC. Lucius Cornelius Sulla successfully transferred administration of the provinces to former consuls and praetors, thus increasing the number of ordinary praetors to 8. Julius Caesar raised the number to 10, then 14, and finally to 16. Imperial Augustus made changes that were designed to reduce the praetor to being an imperial administrator rather than a magistrate. The electoral body was changed to the Senate, which was now an instrument of imperial ratification. To take a very simplistic view, the establishment of the Principate can be seen as the restoration of monarchy under another name. The emperor therefore assumed the powers once held by the kings, but he used the apparatus of the republic to exercise them. For example, the emperor presided over the highest courts of appeal. The need for administrators remained just as acute. After several changes, Augustus fixed the number at 12. Under Tiberius, there were 16. As imperial administrators, their duties extended to matters that the Republic would have considered minima. 2 praetors were appointed by Claudius for matters relating to fideicommissa, when the business in that department of the law had become considerable. But Titus reduced the number to 1, and Nerva added a praetor for the decision of matters between the ficus and individuals. Marcus Aurelius appointed a praetor for matters relating to tutelar praetors as judges. Roman court cases fell into the 2 broad categories of civil or criminal trials. The involvement of a praetor in either was as follows. actions in an actio, which was civil. The praetor could either issue an interdictum forbidding sim circumstance or appoint a iudex. Proceedings before the praetor were technically said to be in iure. At this stage, the praetor would establish a formula directing the iudex as to the remedy to be given if he found that certain circumstances were satisfied. For instance, let X be iudex. If it appears that the defendant ought to pay 10,000 sesterces to the plaintiff, let the iudex condemn the defendant to pay 10,000 sesterces to the plaintiff. If it does not so appear, let the plaintiff absolve him. After they were handed over to the iudex, they were no longer in iure before the praetor, but apud iudicem. The iudicium of the iudex was binding. By the time of Diocletian, however, this two-stage process had largely disappeared, and the praetor would either hear the whole case in person or appoint a delegate, taking steps for the enforcement of the decision. The formula was replaced by an informal system of pleadings. During the time of the Roman Republic, the urban praetor allegedly issued an annual edict, usually on the advice of jurists, setting out the circumstances under which he would grant remedies. The legal provisions arising from the praetor's edict were known as ius honorarium. In theory, the praetor did not have power to alter the law, but in practice the edict altered the rights and duties of individuals and was effectively a legislative document. In the reign of Hadrian, however, the terms of the edict were made permanent and the praetor's de facto legislative role was abolished. Quaestiones perpetuae. The praetors also presided at the quaestiones perpetuae, so called because they were of certain types, with the praetor being assigned to one type on a permanent basis. The praetors appointed judges who acted as jurors in voting for guilt or innocence. The verdict was either acquittal or condemnation. These quaestiones looked into crimina publica, crimes against the public, such as were worthy of the attention of a praetor. The penalty on conviction was usually death, but sometimes other severe penalties were used. In the late Republic, the public crimes were repetundae, ambitus, majestis, peculatus, falsum, de sicarias a beneficus, de patricidis. The last three were added by the dictator Sulla in the early 1st century BC. Outdoor actions. When the praetor administered justice in a tribunal, he sat on a sella curalis, which was that part of the court reserved for the praetor and his assessors and friends, as opposed to the subsellia, the part occupied by the iudices and others who were present. In court, the praetor was referred to as acting e tribunali or ex superior loco, but he could also perform ministerial acts out of court, in which case he was said to be acting e pleno or ex aequo loco. For instance, he could in certain cases give validity to the act of manumission when he was out of doors, such as on his way to the bath or to the theatre. Later Roman era. By 395, the praetors' responsibilities had been reduced to a purely municipal role. Their sole duty was to manage the spending of money on the exhibition of games or on public works. However, with the decline of the other traditional Roman offices such as that of tribune, the praetorship remained an important portal through which aristocrats could gain access to either the western or eastern senates. The praetorship was a costly position to hold, as praetors were expected to possess a treasury from which they could draw funds for their municipal duties. Byzantine Empire. Like many other Roman institutions, the praetor survived in the Eastern Roman Empire. Emperor Justinian I undertook a major administrative reform beginning in 535. The diocese of Thrace had already been abolished by the end of the 5th century by Anastasius, and its vicarius became the new Praetor Justinianus of Thrace, with authority over all the former Thracian provinces except for Lower Moesia and Scythia Minor, which became part of the Quaestura Exercitus. Similarly, the governors of Pisidra and Lycaonia, as well as Paphlagonia, were upgraded to Praetors Justiniani, and received the rank of Respectabilis. In addition, in Constantinople he replaced the praefectus vigilum, who was hitherto responsible for security, by a praetor populi, with wide-ranging police powers. In the early 9th century, the praetor was a junior administrative official in the themator, subordinate to the governing strategos. Gradually, however, the civil functionaries assumed greater power, and by the late 10th century, the praetors were placed at the head of the civil administration of a thema. The division of civil and military duties was in essence reversed again in the 12th century, when the posts of praetor and military do were held in tandem. The provincial post fell out of use after the collapse of the empire in 1204. In the administration of Constantinople, the imperial capital, however, the Justinian-era post of the praetor Demon, head of the police and subordinate to the city's epic, is still attested as late as the mid-14th century. Modern era. Classical Latin Praetor became medieval Latin Praetor, Praetora, Praetora, etc. During the interwar period, the 71 counties of Romania were divided into a various numbers of plesi, headed by a praetor, appointed by the prefect. The institution headed by the praetor was called praetora. Currently, this office has survived only in the Republic of Moldova, where praetors are the heads of Chișinău's 5 sectors. In Italy, until 1998, praetor was a magistrate with particular duty. Books. Brennan, Corey. The Praetorship in the Roman Republic. Oxford University Press. ISBN 0-19-513867-8. McCulloch, Colleen. The First Man in Rome. Avon Books. ISBN 0-380-71081-1.